Hi everyone, welcome to our webinar on the common pitfalls for SaaS and online businesses. My name is Jessica Anderson. I'm a senior lawyer in LegalVision's commercial contracts and online law team. So before we begin, just a couple of housekeeping items. You'll be emailed a copy of this recording and the slides after the webinar. Throughout the webinar, you can submit any questions you have in the chat box, and you can also complete a really quick survey after the webinar. We really appreciate your feedback. And all webinar attendees are eligible to receive a free legal consultation with us to discuss how we can help you with your contracts or any of your legal needs. So to request your free consultation, just provide us with your contact details in the survey that appears at the end of the webinar. Okay, so today I'll be running through 3 key pitfalls that we see faced by SaaS and online businesses. Not having proper contracts or terms and conditions in place, not being compliant with regulatory regimes, and not understanding your privacy obligations. So what is online business? What do I mean when I'm talking about that? Well, common examples include e-commerce websites, software as a service, that's what I mean when I say SaaS, online marketplaces, and mobile phone apps. As lawyers, it's our job to keep an eye out for these pitfalls and stop them in their tracks. So today I'll address the pitfalls and then talk about what we recommend businesses do to overcome them. Okay, number 1, when you don't have a contract or terms and conditions, this is going to lead to disputes and confusion about the arrangement that you actually have with your customers, particularly about things like payment, intellectual property, liability, and termination. So the way to avoid this pitfall is to have a well-drafted contract in place that clearly details each of these things so that both parties are on the same page from the get-go. So payment. For instance, if you run a SaaS, is payment weekly, monthly, annual? Do you take payment in advance or in arrears? Do you use any particular criteria for determining fees and payment? This might be based on level of access or features used or the permitted number of authorized users. If you run an online membership, what does membership actually include? And how does someone upgrade or downgrade their membership? And how might this affect the fees? You also need to cover whether a user can pause or cancel their membership early. You also really need to think about in what instances will you offer refunds or exchanges? For instance, will you allow customers who have purchased goods to get a full refund for change of mind? Imagine that you do allow customers a full refund for change of mind, but only in certain circumstances. You want to ensure that these circumstances are spelled out really clearly in your T's and C's. For instance, you might only allow a full refund for change of mind when the goods are unopened and unused and purchased within a certain time frame, say 14 days. So by ensuring that your customer reads your T's and C's that contains a clear refunds and exchanges policy before making a purchase, there's less of a chance you'll get into an argument about these things later on. And remember that you'll also need to comply with the Australian consumer law guarantees, which I'll touch on a bit later. Intellectual property. Your IP will include all of the code relating to the operation of the website or your platform, any branding, the layout, and the look and the feel of the website. This IP is what makes your business unique. It's where a lot of the value of your business lies. So it's really important that it's protected. In your T's and C's, you might include a license to your platform to grant users permission to use the platform. So for instance, you might say that users can only use the platform for business purposes and businesses can't copy any of your IP or use any of your IP to compete with your business. When you run a SaaS, you'll also need to consider the ownership of any IP from your clients, where that IP interoperates with the platform. An example of this is where your clients can upload their own documents or images or branding to your platform. If this is the case, you'll need a license from them to use such content, and this should also be included in your contract. And your contract also needs to deal with who owns new intellectual property that's created through the use of your online business. So say, for example, who owns any feedback that your users provide to you, or who owns any new IP generated through your SaaS. Again, it's really best to deal with these things from the outset before any disputes or confusion arises. So imagine a scenario where you run a SaaS allowing users to build virtual reality tools, but you don't have a SaaS agreement in place. A customer might use your SaaS and expect the IP in the VR tool they've built to vest in them, or they expect to own that IP, but perhaps you intended to only grant them a license rather than full ownership in what they've built. This could cause a big argument down the track, particularly where this IP is really valuable. Liability. You'll want to put yourself in a position where your liability or your risk, or that risk that you have operating your business, is limited. So for instance, you might exclude responsibility for any materials, IP, or data that your customer uploads when using your platform. You shift the responsibility to them for making sure that they own that data and that they own that IP and that they're not using it to break any laws. You should include a clause that excludes consequential loss. Consequential loss generally means indirect losses, and it's important to have quite a detailed definition of what this actually entails. So a common type of consequential loss is loss of business or loss of profits. An example, so you might run a SaaS offering marketing insights to business customers. So where your customer implements changes in accordance with these insights, but doesn't achieve the results they wanted, this could result in a loss of profits. And you'll ideally want to exclude responsibility for that. This is a very nuanced area of law, so it's important to get advice on how to set up this clause for your business. You should also look to limit your total liability exposure to a reasonable amount. So for instance, to the value of the fees paid for the goods you sell, or the value of the yearly subscription fee. But I note it's really important to balance these limitations and exclusions clauses with a couple of regimes that are in place: this unfair contract terms regime and the substantially prejudicial terms regime. And I'll speak about these a bit later. But essentially, you can't exclude liability for absolutely everything. And these regimes are in place to ensure contracts remain somewhat balanced, and to promote competition in the market, and to ensure that big parties don't have an unfair advantage over small parties. Termination. So it's incredibly important to be clear from the start how each party can terminate the agreement if need be. So if you sell goods on a one-off basis, this is less of a concern for you, but it's going to be quite important where you offer an online subscription or SaaS. So where customers are paying up front, are you going to allow them to terminate early? If so, if they can terminate early, will a cancellation fee be payable? Your contract needs to set this out, but note that you may also have that obligation to not impose any unfair contract terms on customers. So early termination fees really need to be proportionate to the loss or the inconvenience you suffer as a result of your customer's early termination. I'll touch on another related pitfall here, and that is copying another business's contract to use as your own. I definitely appreciate that it's tempting, but it's really not advisable to do this. Other businesses offer different goods or services to you. They deal with payments and subscriptions differently. They deal with delivery and refunds differently, and they may offer different warranties. And not only this, but there are Australian laws, including privacy laws and the Australian consumer law, which need to be addressed in your contracts. And we see a lot of businesses using overseas contracts, which really aren't suitable for Australian businesses. For instance, we often see liability clauses taken from US contracts. We notice them straight away because they're in caps lock and they use excessively convoluted language. But perhaps more importantly, they're often drafted in a way that doesn't align with what's market standard or what's normal in Australian contracts. So pitfall number 2. The next big pitfall we see is not being compliant with regulatory regimes that apply to your business. There could be many regulations that apply to you depending on which industry you're in, but today I'll cover some consumer regulations. If you don't comply with the regulatory regimes, you can be investigated by the relevant commissioner, clauses in your contracts can become void, and you can also be fined. So consumer rights, starting with consumer rights. In Australia, a consumer includes a person or business, and that's important, a person or business who buys or hires goods or services for up to $100,000. So this covers a broad range of customers. It's not just individuals. Australian consumers are given the protection of the Australian Consumer Law, or the ACL. So they're given protection from unfair contract terms. It's a detailed regime, but I'll cover it briefly here. Basically, if your contract is a standard form contract, any unfair contract terms are void. I won't go into a huge amount of detail on what a standard form contract is, but essentially if your contract isn't negotiated, so say it's just take it or leave it terms and conditions, as is the case for many online businesses, it's likely that those T's and C's are a standard form contract. So some examples of unfair contract terms include clauses that try and exclude the provider's responsibilities altogether, and harsh indemnity clauses. So it's important to try and make sure that your terms are balanced. Last year, a bill was passed, so now there are big fines in the millions of dollars if it's found that there are unfair contract terms in standard form contracts. Consumers are also offered protection by way of the consumer guarantees, which, among other things, means that products must be of acceptable quality, they must match their description, and they must come with full title and ownership. And services must be provided with care and skill, be fit for any agreed purpose, and be provided within a reasonable time. So where these guarantees aren't met, consumers have a number of rights, including the right to a repair, replacement or refund of goods, and cancellation of a service and compensation for damage and loss. So this is a good time to point out that your contracts or your advertising can't suggest that you don't offer refunds at all. It's important that you don't confuse consumers about their ACL rights. So while you might choose not to offer a refund for change of mind, consumers do still have those rights under the consumer guarantees. And this is why we often see wording in contracts says something like, subject to your rights under the Australian Consumer Law, we don't offer refunds for change of mind. Having a look at the substantially prejudicial terms regime. So if you are selling to any consumers in New South Wales, and remember that definition of consumers, it's people and businesses buying or hiring goods or services for up to $100,000. So if you're selling to consumers in New South Wales, there are some recent laws that have come into play. You're required to disclose any substantially prejudicial terms to those consumers. Okay, so what are some examples of substantially prejudicial terms? And I think you'll notice that there is crossover with the unfair contract terms regime. Where unfair contract terms are void, substantially prejudicial terms need to be disclosed. substantially prejudicial terms. So some examples are clauses which completely exclude the liability of the supplier. So say, for instance, in a consulting agreement, where there's a clause that completely excludes all responsibility for the customer's reliance on the consulting services provided. Another example is a clause that says that the customer is liable for damage to any delivered goods. An example of this is where a removalist company has a clause that states that the customer takes responsibility for damage to goods being moved. Another example is large exit fees or balloon payments. So touching back on what I said before about making sure that any cancellation fees aren't excessive. An example of this is a really large, excessively large fee to terminate a gym membership. So where this regime applies to you, you're required to take reasonable steps to disclose these substantially prejudicial terms to the consumer. So how do you do this? How do you take reasonable steps to disclose these terms? So the way to do this, the commentary on this is evolving, but at the moment, the way we've seen this being done is by not hiding these disclosures deep within your terms and conditions. They should be presented to your customer before they actually accept your contract. So you might put them on the page where your customer places an order for goods or where they click to sign up to your online SaaS. You might also put these disclosures at the top of your contract so that your customer is prompted to read and accept them prior to reading the rest of your contract. And there are, again, large penalties for not complying with these new disclosure obligations. Okay, pitfall number 3, not understanding your privacy obligations. This basically not understanding and not implementing your privacy obligations can have a number of effects. It can result in complaints from users. It can result in you being investigated by the Privacy Commissioner, and it can result in disciplinary action. So you'll really need to consider what personal information you're collecting from users and how you're handling and storing that information. And all of this will need to be spelled out in your privacy policy. So at the moment, many Australian businesses need to comply with the 13 Australian Privacy Principles, or the APPs. These APPs are found in the Australian Privacy Act. You might have heard that there are really significant reforms happening in the privacy space in Australia. And while some small businesses don't need to comply with the APPs at the moment, it's likely that they will soon. So if you are an APP entity, in other words, a business which must comply with the APPs, there's a number of things you'll need to do. I'll run through a couple of them. So you'll need to have an up-to-date privacy policy, like I said before, detailing what personal information and sensitive information you're collecting, how you're handling it, who you're disclosing it to. And it also needs to outline the rights individuals have with regards to the personal information that you're holding about them. You should really only use personal information for direct marketing in certain circumstances. For instance, where the individual would reasonably expect to receive that marketing, and where there's a simple way for the person to unsubscribe from the marketing communications, and that opt-out or that unsubscribe needs to be actioned promptly. You also need to make sure that when you're disclosing personal information overseas, so say, for instance, you might be using third-party software or servers located overseas, you also need to make sure that that recipient also complies with the APPs, or that they have very good privacy laws that apply to them and that they comply with. If your business is handling sensitive information, such as health information, your customers are definitely going to want to see that you're handling that information in accordance with the Australian privacy principles. So for instance, you should only collect sensitive information with the consent of the person from whom you collected it. And you should only use sensitive information for the primary purpose for which it was collected, and not for other unrelated purposes. An example of this is where you provide a medical SaaS business and you collect health information. You should only use that health information to actually offer your SaaS and offer the features of your SaaS. If you intend to use the information you've collected for other purposes, for example, disclosing it to a third-party university for research purposes, you'll need clear consent. You'll need to seek that clear consent from your user before you disclose it. As an online business, you might use third parties such as payment processors and delivery partners, and like I said before, overseas servers or suppliers. And all of these third parties need to be set out in your privacy policy, along with the reasons that you're actually disclosing the information to those parties. Okay, so this that's the main part of the webinar, but we do have some questions coming through, which I will get to. So we have a great publication here. It's the 6 Key SaaS Contract Essentials cheat sheet. You can access that in the handout section in your webinar panel. While you continue to submit your questions, and I have seen questions coming through, which is great, while you do that, I'll take a moment to tell you about our membership. So LegalVision's membership is a really cost-effective alternative to the expensive hourly rates you might have experienced with other law firms. So for an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document reviews, including drafting, amending, reviewing business contracts. So this includes drafting your terms and conditions, drafting your SaaS agreement, and then other business contracts like your commercial lease if necessary. It includes unlimited advice consultations with our team of over 100 specialized lawyers. We can advise on things like business structuring, employment, dispute resolution, and lots more. And membership also includes unlimited domestic trademark registration. So as a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel will take care of all the business as usual legal work so that you can focus on running your business. And if you are an in-house counsel, we have a lot of in-house counsel on board. Our membership is a cost-effective solution for outsourcing legal work. So we'd love to talk to you more about how membership can help you. So to do that, just request a free consultation when the survey appears at the end of this webinar. And now I will answer some of the questions that have come through. Okay, so this one says, as a business owner, what are my obligations regarding privacy and collecting and holding customer data online? Great question. So this was a pre-submitted question. So hopefully I've at least somewhat touched on this, but of course, privacy laws are really complex and are evolving constantly. So there's lots more detail and advice we can provide that's particular to your business. A few other things to keep in mind. So I think one thing is that it's really important that you're continually checking in to ensure that your business complies with the APPs. The Privacy Act requires that you're constantly updating your privacy practices, updating your privacy policy, and considering if you actually need the information that you're holding, and considering if you actually need to request the information you're asking for in providing your business. And as I mentioned, significant reforms are happening in this space. And if you haven't previously had to comply with the APPs due to the small business exception, you might need to soon. So individuals will be getting more rights, and businesses are going to be facing increased penalties for non-compliance, and businesses will also need to respond to data breaches more quickly. And I briefly touched on this, but I'd really emphasize the requirement to only collect personal information that you reasonably require to run your business and provide your goods and services. So if you have an extensive contact form on your website or platform with a number of mandatory fields collecting lots of personal information that you don't actually need, this can be problematic. I'd consider looking at those forms and assessing, do we really need all that information that we collect, or can we run our business without some of that information? Make sure that you have a privacy policy that's prepared specifically for your business. This is particularly important if you have an app on the Google or on the App Store or the Google Play Store. Google and Apple often review your privacy policy, which you need to upload when putting your app on the App Store. And then making sure that the privacy policy is very detailed and specific about what sorts of personal information you're collecting and who you're disclosing it to. Have a look. One of the questions says, does LegalVision offer a blueprint for online SaaS product terms of service? So, I mean, yes, absolutely. If you're a LegalVision member, that's included in your membership. We will draft your SaaS terms of service for you. We like to have a consultation with you and learn more about how your SaaS works, what your concerns are, how you do, like I said before, how you do things like payments, liability, termination, refunds, pauses, all those sorts of things. And then we'll prepare your SaaS terms of service in such a way that aligns with the way you offer your SaaS. So you might offer SaaS via an app or an online platform, or you might offer a much more bespoke SaaS where you're really negotiating the terms of service with each customer, and you have more of a sort of order form or a proposal that's bespoke for each customer. We can prepare your document in a way that aligns with the way you run your business. Let me have a look. So I've sort of touched on this. If the proposed changes to the privacy law are enacted, including the removal of the small business exception or exclusion, what effect will this have on SaaS providers? Yeah, it's great that you're thinking about this. Basically, with the removal of the small business exception, it means that you will become an APP entity. So you'll need to do all of those things that I talked about. Having an up-to-date privacy policy, responding to data breaches promptly, making sure that you're keeping data secure, and making sure you're giving individuals those rights they have under the Privacy Act. So rights to access their information, correct their information, the right to be anonymous if that works with your business. Have a look at the next questions. Someone's asked, what do I need to think about when I'm getting a developer to build my platform? So we've assisted parties on both sides of this. We work with a lot of software developers. We also work with many businesses who are engaging developers to build their software. So you're going to want to have a really good software development agreement in place. So this is going to cover the deliverables, the scope of the work, and any dates for completion of each of the milestones. It's often a sort of milestone regime in the development world. This is then tied to payment. So we need to consider, is it a fixed fee job, or are you paying the developer upon completion of each milestone? There's obviously a preference there depending on whether you're the developer or the customer. There should be a process for acceptance testing, setting out how you actually go about testing each component before it's rolled out. And I think perhaps most importantly is IP ownership. So if you are engaging a developer to build custom software for your business, you want to make sure that you actually own the IP in the software so that you can adequately commercialize it, use it, edit it yourself. And if the risk is that if the developer owns the software and or the IP in what they've built for you, that's going to restrict you a little bit, or potentially quite a lot. It might limit how you can commercialize your software, and it's definitely going to be an issue down the track if you want to sell your business. Any potential buyers of your business are going to want to see that you own all of the IP that's tied up, and that is the value in your business. So in all your contracts, it's important that you own that IP that you're having created. A great question is what is the best way to draft privacy documents and T's and C's that cover Oz, US, EU, and UK? So this is coming up more and more, and it's particularly relevant in the SaaS and online business world because you're offering services that are available worldwide. So I'd encourage you to, if you're an Australian business, I'd encourage you to think about having these documents drafted initially in Australia. Australia, both your T's and C's and your privacy policy, so that they're aligned with the Australian market. These T's and C's and privacy policies can still be read and accepted by people overseas. That's not an issue, and it's very common for Australian businesses to offer goods and services and online businesses worldwide, and it doesn't mean you have to have one version of your contract in every single country in which your platform is available. But at the point where you're really marketing or targeting users overseas, that's when I'd start to think about, okay, do we need a version of this contract that's suitable for people in that particular country, or do we need to comply with, say, the GDPR? That's another thing we can speak to about in a lot more detail, GDPR compliance. And I know it's incredibly important for many of our clients because they're sort of dabbling in the UK or the EU, and they're wondering, do I need to comply with the GDPR at the moment? And we like to have a more thorough chat with you about, how is your platform simply available in the EU, or are you really actively targeting and marketing to people based in the EU? If the latter, it's a possibility that you need to comply. So a bit of a case-by-case basis. Nothing wrong with starting in your sort of home country, Australia, and then as you're broadening your reach and really targeting those customers in those countries, we might think about dealing with or getting the assistance of a firm overseas for tweaking the T's and C's so that they're compliant with that market, and updating your privacy policy so that it complies with those overseas laws. So we often see Australian businesses have a sort of schedule at the end of their privacy policy, or an addendum at the end of their privacy policy, setting out all the things that are particular under the GDPR. Okay, so someone's asked, how do I get people to agree to my terms and conditions? Is click to accept enforceable? So yeah, this is absolutely one of the most common ways we see online businesses and SaaS businesses present their contracts. It's a click to accept process. You are going to want to make sure that your users and customers actually have a chance to read through your terms and conditions. We see this done with boxes that appear where the customer needs to scroll through to the end and they can't tick to accept until they've scrolled through, or they can't sign up until they've ticked a box indicating that they agree to the T's and C's. This is particularly important, again, going back to that obligation to disclose any substantially prejudicial terms to consumers in New South Wales. And it's important to keep a record of each user's acceptance. I'd also mention that it's really not good enough to just have your terms and conditions in a hyperlink at the bottom of your website. If users aren't prompted to actually read through and accept them, there's a very high chance that they won't, and then you're going to have trouble demonstrating, if there was a dispute, demonstrating that they actually read your contract and understood those things about liability and intellectual property ownership and refunds. So really make sure that your user is prompted to accept your terms prior to signing up, and that you keep a record of each user's acceptance. And someone's asked a question about a data breach, which is a great question. So how do I keep the data that people share with our SaaS? How do I avoid a data breach? Okay, so under the APPs, one of the APPs talks about security of personal information, and where you hold personal information, so which I can't remember if I touched on this before, but personal information is any information which identifies someone. So all your basic contact information, names, phone numbers, email addresses, but it also includes things like payment details. It includes their marketing preferences and the way they actually use your website and your platform. So APP 11 requires you to take reasonable steps to keep the data secure. And you can do this with lots of practical measures. So encryption, strong passwords, using pseudonyms where possible. Physical security is obviously really important. Your office needs to be physically secure. Laptops, ideally information shouldn't be stored locally on laptops in case the laptop or the device gets stolen. You should limit who in your team actually has access to personal information, particularly if it's sensitive or highly confidential information, and limit that on a need-to-know basis. And then along those lines, really limit the third parties who you share information with. Make sure your suppliers are, do your due diligence on your suppliers. Make sure that they have legal and contractual obligations to comply with privacy laws, and that they have they're contractually required to have good security systems in place. Yeah, it's a great thing to be thinking about. And on data breaches, so if you are an APP entity or if you're likely to be one soon, you'll need to comply with the notifiable data breaches scheme. So in short, a data breach is notifiable if it can potentially cause harm, or if it's likely to cause harm, I should say, and you haven't been able to take any action to prevent that harm. So if it is a notifiable data breach, you might have to notify the Privacy Commissioner and any affected individuals. Okay, just having a look. We're almost done for today. Just have a look if there are any other questions I can answer. So someone's asked regarding, this is a great question, regarding consumer guarantees for customers buying up to $100,000. Does that refer to a single transaction purchase or all purchases over the term of the contract? That's a great question. It really depends on how you structure your business. If you're selling one-off goods for up to $100,000, that's going to be that is going to fall under that $100,000 requirement, I suppose. But if you do have a long-term contract that could exceed that $100,000 limit, then it's possible that that doesn't fall under that $100,000 limit, and so therefore it doesn't apply. The consumer definition doesn't apply. It is a bit of a case-by-case basis. We've looked at different clients' contracts and how they actually structure their offering, and sometimes it can fall under that $100,000 limit, and sometimes it can go above it. So we like to give advice on a bit of a case-by-case basis for that one. Look, that's all we have time for today. Really appreciate the questions and your engagement. If you have further questions, or if there's something I haven't answered, we'd love to speak to you about that in a consultation. So to request a consultation, a survey is going to pop up after this. We'd really appreciate if you can complete the survey. Just include your details to receive that consultation. And that's all we have time for. Really appreciate you joining me. Have a great rest of your day.